Hello, everyone, and welcome to Uncivil Law. For today's case, we have a case from the U.S. Court of Appeals for the Sixth Circuit coming out of Michigan. This is the case of United States of America versus Frank Richardson. And Frank Richardson is, well, either the luckiest or unluckiest person in the world, and the Sixth Circuit is either doing their job or completely stubborn. We will all decide together. But Frank Richardson has been convicted and sentenced of crimes. He has twice gone to the U.S. Supreme Court. The Supreme Court has twice vacated his sentence, and now he's here for number 3. So is the Sixth Circuit paying attention? Did they get this one right? Will this be appealed? Are we going for a trifecta? Let's find out. Let's get started. We must give credit when it's due. Twice, Frank Richardson has successfully persuaded the Supreme Court to vacate our judgments, affirming his conviction and sentence for a string of armed robberies in Detroit, which would think you would get their attention, but both times the Supreme Court remanded Richardson's case to this court, and although not reversing our decision on the merits, instructed us to consider whether intervening Supreme Court decision or new legislation affected his conviction under the law. After we first affirmed Richardson's conviction and sentence for the first time, the Supreme Court asked us, they didn't really ask, they directed, but okay, they asked us to consider whether its decision in Johnson v. United States from 2015 affected the conviction. Richardson argued that the clear import of the case, which held the Armed Career Criminal Act residual clause is unconstitutionally vague, was that the similar act, but not identically worded, residual clause was also void for vagueness. And a fairly reasonable argument, right? If you have multiple statutes, and they're all in the criminal law, and you have one statute that's been expressly ruled by the Supreme Court to be void for vagueness, and you have another statute in a different section which is similarly worded, then you can reasonably conclude that it also is void for vagueness. So that's a very reasonable argument. It doesn't have to be, but it certainly would seem to be on first impression. So what did the court say? But we held that Richardson's underlying conduct, aiding and abetting a Hobbs Act robbery, which again is just robbery, but occurring in interstate commerce, so there's federal jurisdiction. So when you hear Hobbs Act robbery, just think robbery. You're there. Satisfy the elements clause, a separate basis for conviction, and thus affirmed his conviction and sentence. So, we were remanded the first time. We considered it in that light. Yeah, we don't see a problem. Sentence is still good. Are we done yet? Richardson petitioned for certiorari again, and while his petition was pending, the First Step Act of 2018 became law. That act makes several changes to the sentencing law, including a major change in which the way courts sentence repeat offenders under the law. So Richardson filed a supplemental brief in support of his cert petition, and in turn, the Supreme Court granted Richardson's petition, vacated our judgment, and remanded this court with instructions to consider whether the act affects Richardson. This guy has gotten his case before the U.S. Supreme Court twice. Twice. I mean, that's like amazing. And now, because for the second time they're being vacated and told to reconsider it, now they're going to change their mind, right? Let's see. We begin by reissuing our earlier decision with a few non-substantive changes affirming the conviction. Nope. I know we're on try number 3, but we got it right the first 2 times, and we're right on number 3. This is totally not a problem. Supreme Court, we've considered it. No problem. We're good. Man, jeez, oh Lord. I feel like they're not reading between the lines a little bit, I have to say. As to the most recent remand, because there's more than one, so yeah. We hold Richardson cannot benefit from the First Steps Act because the district court resentenced him more than a year before the act became law. As a result, we also reaffirm the sentence. Are we going for 3? Is the Supreme Court going to take cert again? Who knows? Let's find out. Frank Richardson participated in a series of armed robberies of electronic stores in and around Detroit, Michigan between February and May of 2010. Richardson planned each heist and served as lookout, although he never entered the store while a robbery occurred. Even so, at least one robber used a gun during the robbery. And remember our discussions on conspiracy law? That means every robber used a gun. Everyone's guilty of everything. That's conspiracy law. Law enforcement apprehended Richardson shortly after he participated in the 5th and final robbery. In June 2013, a jury convicted Richardson of the 5 counts of aiding and abetting robbery under federal law, 5 counts of aiding and abetting the use of firearm during a crime of violence, and 1 count of being a felon in possession of law. The district court sentenced Richardson to 1,494 months in prison, which, by the way, is about 120 years, and we reaffirmed Richard's conviction and sentence on appeal. Things are not going very well for Richardson, but you probably shouldn't have robbed the stores those 5 times. That would have been good. 1,494 months, man. You're going to need one heck of a calendar to mark off the days of that one. Jeez. While Richardson's appeal was pending, the Supreme Court decided the case of Johnson, holding that the Armed Career Criminal Act residual clause is unconstitutionally vague. Although the jury did not convict Richardson under the Armed Career Criminal Act, he petitioned for certiorari, arguing that this statute's residual clause, though not identical to the Armed Career Criminal Act residual clause, is similarly vague. A perfectly reasonable argument. The court granted the judgment, vacated, and remanded for further consideration in light of that case. So he's arguing, hey, this residual section is unconstitutionally vague. And the Supreme Court, as is not atypical and probably more typical than not, because the court below didn't have the chance to consider it, they send it back below to have the court below consider it in the first instance. Now, personally, I think this is just like a little bit of time saving from time saving for the court, because the court could just decide the issue, right? They know the answer, but they're sending it back to give the court below a chance to get it right, and then they'll consider it on the merits if they have to. But if they come up with the right answer, then the Supreme Court didn't have to do it. So they're saying, hey, you should have considered it in light of this case. So please take another crack at it and see if it's valid under this case. Okay, so how did the Sixth Circuit deal with that? In September 2017, the district court held a resentencing hearing and reinstated the original sentence. Richardson appealed, and in October 2018, we issued another opinion affirming the district court's restatement of the original sentence. We just said, nope, we got it right before. We got it totally right. We don't know the problem. Everything is completely fine. So, yeah. Once more, Richardson petitioned the court for certiorari, and while the petition was pending, Congress passed the First Step Act of 2018. Because one part of the First Step Act changes how courts sentence defendants convicted of multiple counts of the statute, Richardson filed a supplemental brief in support of his petition, claiming that he's entitled to relief under the Act. Again, the court granted Richardson's petition, vacated our judgment, and remanded this court to consider in light of the First Step Act. So again, it's like we could decide this, but we're going to give you the lower court, because you're the lower court, Sixth Circuit Court of Appeals, lower. We're going to give you a chance to consider this and get it right. So we send it back again. So now we go to time number 3. Will we come up with a different result on try number 3? Let's find out. We begin with the first Supreme Court remand from 2016, which asked us to consider the invention being given in Johnson. In response to that order, we remanded the case to instructing the district court to consider whether Johnson affected the sentencing. So everyone is going to the level below them. Supreme Court says, we don't want to figure it out. Sixth Circuit, you figure it out. The Sixth Circuit says, we can't be bothered. We're sending it back to the trial court. Make them figure it out. Maybe they'll get it right. We can't be bothered. So everyone is going down the chain, and then the district court is left with, well, maybe I can assign it to my clerk, and that's about as far down as we can go. Next, we consider the central issue properly before us from the Supreme Court's first remand, whether the court's decision in Johnson had any effect on Richardson's sentence. The Armed Career Criminal Act at issue in Johnson creates no standalone criminal offense. Rather, it imposes a more severe sentence on a defendant convicted of being a felon in possession of a firearm, but only if the defendant has 3 or more convictions for a violent felony or a serious drug offense. The Armed Career Criminal Act provides several definitions for the term violent felony, including a catch-all definition within a residual clause. Any crime punishable by imprisonment for a term exceeding 1 year that otherwise involves conduct that presents a serious potential risk of physical injury to another is a violent felony under the Armed Career Criminal Act residual clause. And I cannot begin to tell you how many Supreme Court cases there are in trying to interpret this clause. It's come up more than once. Yeah. The Supreme Court held in Johnson that the Armed Career Criminal Act's residual clause is unconstitutionally vague. Richardson, however, did not receive a sentencing enhancement under the Armed Career Criminal Act, and he does not challenge his conviction to one count of being a felon in possession of a firearm. Instead, he appeals his conviction under a different statute, which makes it a separate offense to use or possess a firearm in connection with a violent or drug trafficking crime. Like the Armed Career Criminal Act, this law includes a residual clause that defines crime of violence as any crime punishable by imprisonment for a term of more than 1 year that involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. Although Richardson acknowledges the residual clause is not identical to this residual clause, he argues the differences between the two clauses are minor, and the Supreme Court's reasoning in Johnson applies to the residual clause too. When we decided Richardson 2, because it's our second shot at it, the Supreme Court had not ruled yet the residual clause is constitutionally vague. But in a published decision after Johnson, but before Richardson 2, we held the residual clause is constitutionally sound, noting the clause is considerably narrower than the statute invalidated by the court in Johnson. So there was an interim period here, right, while the Supreme Court was considering it in another case. And the Sixth Circuit wrote, okay, Supreme Court hasn't ruled on this yet, but we say that even though the Supreme Court hasn't ruled on this, we're going to predict the future. We say that these clauses are different enough and the reasoning does not apply to the 924 residual clause. They're different enough, the reasoning does not apply. Did the Sixth Circuit get that decision right? No. After our decision in Richardson 2, the Supreme Court addressed the validity of the statute's residual clause holding that the clause is in fact unconstitutionally vague. Yet another interpretation you got wrong there, Sixth Circuit. You said, not a problem. Supreme Court said, we disagree. It is a problem. You're just not doing very good on this law interpretation thing these days. But Davis does not gut the entire statute. To the contrary, Davis leaves intact a separate definition of crime of violence supplied by a statute's elements clause. That clause defines crime of violence as a felony that has an element of the use, attempted use, or threatening use of physical force against the person or property of another. With the residual clause now gone, we can uphold Richardson's conviction and sentence under the statute only if the statutes underlying his conviction, aiding and abetting Hobbs Act robbery, satisfies the elements clause. Although we have not addressed whether aiding and abetting Hobbs Act robbery is a crime of violence under the elements clause, we have held the principal offenses of robbery is a crime of violence under the clause. And fair enough. There could be distinguishments between aiding and abetting and the crime. You know, you usually go to the crime, but it might not necessarily be a crime of violence, even though it is for the principle. So there might be a separation there. You know, this is like what I said about conspiracies. You know, most of the time it follows, aiding and abetting most of the time follows, but here it's like we haven't ever addressed whether aiding and abetting qualifies as a violent crime unto itself, which, you know, kind of makes sense because they themselves didn't do anything violent, but maybe they're liable for it anyway. So what does the Sixth Circuit have to say? And do we trust what they said? Let's read on. In Gooch, great case name, we explain that the Hobbs Act is a divisible statute that creates two separate offenses, Hobbs Act extortion and Hobbs Act robbery. And we conclude the latter is an offense that's categorically a crime of violence. Okay. Richardson acknowledges our holding in Gooch, but argues his conviction for aiding and abetting Hobbs Act robbery, unlike a conviction for a principal offense, is not a crime of violence under the Elements Clause. We disagree. There's no distinction between aiding and abetting the commission of a crime and committing the principal offense. Aiding and abetting is simply an alternate theory of liability indistinguishable from the substantive crime. You know, that is the answer I would come to normally, but because the Sixth Circuit wrote it, I am now doubtful. So I am now doubtful that is the correct answer. If you had asked me, is that the correct answer? I would have said yes. But now they wrote it down, so I don't know anymore. That's not so sure about that one. Maybe we'll find out. Let's carry on. Moreover, the 1st, 3rd, 10th, and 11th circuits have held that aiding and abetting Hobbs Act robbery is a crime of violence. Well, that is somewhat more encouraging, so maybe I can rely on that. But I don't know. The 6th Circuit wrote it, so I still don't know. We agree with our sister circuits and conclude that Richardson's conviction for aiding and abetting Hobbs Act robbery satisfies the element clause. So, for the 3rd time, we affirm his conviction. This just in, Sixth Circuit says sky is blue. I'll tell you what, man, I'm peeking out my head out the window and I'm looking. Finally, we turn to the second and most recent remand from the Supreme Court, but perhaps not the last remand from the Supreme Court. The court vacated our judgment in Richardson 2 and asks us to consider the First Step Act of 2018. We do so now. One of the First Step Act's provisions amends the sentencing language. To be clear, the Act does not change the mandatory minimum sentences for defendants convicted of possessing, brandishing, or discharging a firearm during a crime of violence. Moreover, the statute has always imposed stiffer penalties for repeat offenders, and while the Act does not change that either. So today, a defendant convicted under the statute with a prior conviction under that section is still subject to mandatory prison of at least 25 years. But the Act does change what counts as a prior conviction, and that change is significant. Is it significant enough to affect what's going on here? Let's read more. When the district court resentenced Richardson, I guess for the second time in 2017, the law prescribed that in the case of a second or subsequent conviction under the law, the person shall be sentenced to not less than 25 years, which is perfectly normal, like repeat offenders normally get additional time. Fine. That raised the question, what counts as a second or subsequent conviction? The Supreme Court answered that question in Deal versus United States. There, the court interpreted the word conviction to mean finding of guilty by a judge or jury that necessarily precedes the entry of a final judgment of conviction. Thus, the court held that 25 mandatory minimum sentence attached when the defendant is convicted of multiple counts in the same proceeding. First of all, I don't know that I necessarily agree with that reading, given what the Supreme Court said, but okay. But the rule before apparently was if you're prior convicted, even if this is your first conviction. So if you have multiple felony counts, then those count as prior convictions somehow. So that was the ruling before. Multiple counts in the same conviction count towards prior convictions, not even though they seem contemporaneous to me. But okay, that's what the rule apparently was before. Let's read on. To contextualize that holding, imagine a defendant with no criminal history who was convicted on 2 counts of the law, the subsection that criminalizes brandishing a firearm during a crime of violence. On the first count, the defendant would face 7-year mandatory minimum. As to the second count, the court must treat the defendant as a repeat offender given the conviction of the first count and therefore impose a 25 mandatory minimum for that count, and they run consecutively. So yeah, a person with no prior convictions, who in this case is being charged with 2 counts. The first count he's convicted of, he gets 7 years. The second count, he has a prior conviction, the one we just entered. So we give him 25 more years, because they're consecutive. Press X to doubt. Richardson had no prior convictions under the law before the jury convicted him of his 5 counts. Richardson's first count was for brandishing a firearm, so the district court imposed the mandatory 7-year sentence. No problem. And under Deal, the district court treated Richardson as a repeat offender and imposed 25 mandatory minimum sentences for each of the remaining 4 counts separately, right? Because they're all crimes involving a firearm, right? They're all separate convictions. So the first crime, you get 7, and then for each of this following 4, that's 25 each minimum consecutive, which brings us to the total of 107. That's how we get 107. For one conviction, because they're prior crimes. Press X to doubt. Enter the First Step Act. The Act amends the law by eliminating the phrase second or subsequent conviction and inserting the clause violation of the subsection that occurs after a prior conviction under this subsection has been made final. That means a defendant would, in a general sense, have to be a repeat offender with a prior final conviction to be eligible for the mandatory enhancement, which I think is kind of what the law said before, but Congress overruling a bad court decision, as they can do. When it's bad, court should overrule the court, right? So here they said, no, what we meant by this was it has to be a second after it's final. So it has to be a distinct matter. So you can't do this anymore. That's not what we had in mind. So the Congress actually made the criminal law a little bit easier on criminals, which you don't see every day, but that's what they did to clarify the law. Fine. So if the Act applied to Richardson, he would receive a 7-year sentence for the first count under the law, and 7-year sentences also run consecutively for each of the other 4. Thus, he'd receive a 35-year sentence if the district court were to sentence him today under the backdrop. So we see there's a pretty big difference here, right? We're going from 107 to 35. Now, each of these are distinct, so you can make them, but they're not subsequent. So each gets 7 for subsequent crimes. That makes sense, but he's not a prior offender. So the issue is, does he get 35 years, in which case he might see daylight someday, or does he get 107 years, in which his daylight opportunities are much less likely? So let's read on. The question before us is whether Richardson can benefit from the First Step Act's amendments. We note at the outset that the relevant section of the Act, Section 403, contains a specific subsection describing the Act's applicability to pending cases. The subsection states, this section and the amendments made by this section shall apply to any offense that was committed before the date of the enhancement of this Act if a sentence for that offense has not been imposed as of such a date of the enactment. Common sense, which Sixth Circuit, so, take with a grain of salt, but common sense would seem to dictate that if the Act did not apply to Richardson, since the district court resentenced him more than a year before the Act became law. But Richardson makes 2 arguments for why he's entitled to resentencing, and we consider each in turn. Yeah, the district court didn't know about this, so the district court couldn't do anything about it because it hadn't happened yet. So the district court is bound by the law, no matter how stupid it is. So yeah, the district court had to do this. So this is not a fault of the district court. It may very well be a fault of the Sixth Circuit because, Sixth Circuit. But yeah, so let's see what they have to say now. First, Richardson argues that the new section does not create a new law, but clarifies what the law has always meant. He finds support in the title, which reads, Clarification of the Section of the Code. According to Richardson, Congress has made clear that the courts should have never sentenced defendants like him with no prior final convictions as repeat offenders even before the Act. So he's saying it's not new law, it's clarification of the law as it always was. So Congress didn't really change the law so much as telling you adults, this is what we always meant, by the way. And to support this argument, he points to the fact that it says in the title of the bill, it says clarification. So he says, hey, this is a clarification because Congress called it a clarification. So it's a clarification. Does the Sixth Circuit agree? Let's read on. The distinction between a new law and clarification can be significant. Yeah, you think? When Congress replaces or changes an existing criminal law, we presume the new law does not alter penalties issued before the new law took effect. Indeed, under the General Saving Statute, the repeal of any statute shall not have the effect to release or extinguish any penalty, forfeiture, or liability incurred under such statute, unless the repealing act shall so expressly provide, and such statute shall be treated as remaining in force for the purpose of sustaining any proper action or prosecution for the enforcement of any such penalty, forfeiture, or liability, and that's in Title 1 of the U.S. Code, Section 109. So basically what that says is that when we repeal a law, it still applies to you if it applies to the time, unless the law itself says it doesn't. So this is the general saving clause, right? So the law, as it was, does exist and continues to exist for you. It continues to exist for you. That was the law that has existed. That's the law you were convicted under. And as far as you're concerned, that is the law that existed and continues to exist. And also this new law also exists at the exact same time. So you can also violate the new law even though you're being held to the old law, which makes perfect sense, right? Congress can change its mind without necessarily wanting to have retroactive effect. And Congress can have retroactive effect. Congress can retroactively free prisoners. They can do that. They can't retroactively convict prisoners, of course, because that would be a bill of attainder in addition to double jeopardy. But they can retroactively release prisoners. And so under the General Saving Statute, it says, well, that's not normally what we mean unless we say so otherwise. Okay. So if the First Step Act changed rather than clarify the law, we would expect that change to operate prospectively and have no retroactive effect on the defendant who had been convicted and sentenced. By contrast, a clarification spells out the statute's original meaning. As to that much, I probably agree with the Ninth Circuit. Yeah, I apologize, the Sixth Circuit. I'm so used to the Ninth Circuit from back in the day being the whipping boy that I just said Ninth by reflex. But now it's the Sixth Circuit that does this. So it's the Sixth Circuit, and it's like, yeah, I agree with the Sixth Circuit as to that. Yeah, if we think it's a change, it's prospective. If it's a clarification, then it's retroactive. Okay, I'm on board. Let's go on. Richardson argues that Section 403, much like the Pennsylvania Supreme Court decision in a different case, simply clarifies the interpretation of the statute, explaining what the law always meant, and thus applies to defendants like him. But the case provides no such support here. In that case, a court was performing its traditional function of construing a statute and did so in a way that contradicted how the executive had enforced it. That Congress altered the statutory language alone provides at least some hint the amendment changed the laws. That Congress altered the statutory language alone provides at least some hint the amendment changed the law rather than clarified what the law always meant. That makes no sense to me at all. That makes no sense to me. That Congress altered the language provides a hint that Congress is changing the law rather than clarifying. Okay, please enlighten me, Sixth Circuit. If the Congress was interested in clarifying the law, how could they do that without changing the wording? So if they wanted to clarify, not change, how would they do that? I would think they would do that by passing a law that changes the wording. So that Congress altered the language provides some hint that it is changing rather than clarifying. Makes no sense to me at all. Because how could you do that? I mean, someone suggested in chat they could do so by adding definitions, but that would change the law too. There's no way to change this without changing the wording somewhere. So yeah, if you change a definition of something, like, I don't know. Because the law means what Congress meant at the time it wrote it. So Congress adding definitions now doesn't necessarily mean it's the same definitions Congress meant when they wrote it the first time. So I don't know necessarily flows. So I don't even know what this sentence is purporting to hold. This sentence makes no sense to me. I don't get it. I don't understand this. Even so, the Act's plain language confirms this presumption while making clear the Act changes do not apply retrospectively. Congress itself addresses the Act's applicability to pending cases. That subsection states the Act's amendment shall apply to any offense that was committed before the date of the Act if the sentence for the offense has not been imposed as of such a date of enactment. From that, we infer that Section 403 shall not apply to any offense committed before December 21st, 2018, if the sentence for that offense had been imposed by that date. Far from suggesting the amendment clarifies what Congress already meant, Congress has in essence drawn a line in the sand. Defendants sentenced to after that may benefit from the amendments, but defendants sentenced cannot. But then there's the pesky fact that Congress, in its title section, used the word clarification. So does that have any impact? What about the section's title using the word clarification? To be sure, we may consider the title when we're interpreting an ambiguous statute, but we need not refer to titles which do not carry the force of law when the statutory text is clear. So Congress wrote the word clarification, but it wasn't a clarification, it was change. Now, I do have to concede the standard premise that titles usually don't have operative effect in terms of substance. But when the issue is this clarifying or is this changing? If Congress writes clarifying in the title, I'm going to assume that was their intent because that's the word they used, So I'm not so sure about that one. I'm not so sure there, Sixth Circuit. Another trip to SCOTUS may be in your future. For these reasons, Richardson is ineligible for relief under the First Step Act, and we affirm, once again, his conviction and sentence to 107 years. I don't know, guys. I don't know, guys. I'm not sure about that one. Like, it makes sense and seems reasonable, but it's the Sixth Circuit, so not so sure. Man. Not so sure. With two prior remands, not so sure. So that is the end of the case from the Court of Appeals for the Sixth Circuit, in this case of United States of America versus Frank Richardson. In this case, we learned that Mr. Richardson was convicted of being a career armed robber, which it appears that he was. And the Supreme Court has twice reversed its sentence and asked the court below to reconsider it in light of new facts. The Sixth Circuit, for the third time, says, no, we got it right the first time, and sentences him back to 107 years. Now, on the one hand, I think what the court said makes sense and is reasonable. But on the other hand, it's the Sixth Circuit, so I don't know, man. I don't know. I have my doubts as to whether or not this is the right conclusion. So whether or not there will be another hearing for certiorari, or whether or not the Supreme Court will grant it again and reverse again, we shall see. But until next time, later. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.